Hey, I get a lot of questions as a lawyer about what the heck does that word mean, Jenny? I'm Jenny Bradley with Triangle Smart Divorce, and I'm going to tell you some quick legal vocabulary 101 to help you understand what your lawyer's saying. But know that my definitions are based on North Carolina law. These words may mean different things in other states. Separation agreement is a term you might hear a lot. So talk about what that means briefly. First of all, it's a little bit of a misnomer. You don't have to be separated to enter a separation agreement. And most people are actually talking about the document that sets the terms for who can do what and who's getting what when they're separated, and that's called a separation agreement and a property settlement. But we shorthand that to separation agreement a lot. So what is it? It's a contract. It's an agreement between you and your spouse that basically says, this is what we're doing for custody, this is what we're doing for spousal support, or it waives spousal support, this is how we're dividing our assets, and then it has a few things in there so that you can enforce this agreement. Like any contract, what good is it if it's not enforceable? So that's basically what it is. It's a private contract between you and your spouse that outlines the terms for your separation and ultimately what's going to happen for your future. Why does North Carolina use the term absolute divorce instead of just saying a divorce? Well, without getting into a lot of history, it's because North Carolina sometimes is a little weird, and we still have this thing called a divorce from bed and board. So just a brief moment on that. That is a court-ordered legal separation, but it doesn't end your marriage. It doesn't allow you to remarry. It doesn't give you a certificate of divorce that you can take to the Social Security Department and change your name or be able to draw benefits on your spouse's earning. It really is just a court-ordered legal separation. So absolute divorce, that's what most people call divorce. That's the piece of paper that says, our marriage is over. You're single now. You can get remarried if you want. If you don't want to, I understand, but you can do that too. So the other thing that people don't realize in North Carolina sometimes is you can get divorced without having any of your other claims resolved. If you need your house sold, if you need bank accounts divided, if there's retirement to talk about, even custody and spousal support, none of that stuff has to be resolved first. You can resolve it after the divorce, as long as your claims are pending for spousal support and equitable distribution. You can resolve it after divorce. Custody and child support can be dealt with at any time, whether you've asked the court to address the issues or not. So, divorce in North Carolina is another fancy legal word here, bifurcated. A lot of states don't do this, but what that means is we don't hold your divorce hostage for you to settle things. And likewise, that sometimes makes it last a lot longer here. But you can get divorced in North Carolina after being separated for a year and a day, and you can file and make that happen whether you have resolved a thing. What is equitable distribution, or as some lawyers call it, ED? Well, that is a phrase in the North Carolina law that means when you are separating and ultimately going towards divorce, your assets will be divided as well as your debts. Which assets and debts is really important though. First of all, there's a difference between marital property and separate property and divisible property, and then property that has characteristics of a little bit of all of those things called mixed property. And I'll give you some examples in a second. But know that in North Carolina, the presumption, that means we start with an assumption that 50-50 is fair. Yes, I use the air quotes there, fair, because really nothing about divorce is fair. But nonetheless, the assumption and presumption is that 50-50 is a reasonable place to start. And then there are factors that can make it sway one way or the other if you appear in front of a judge. You can also negotiate for something different than a 50-50 split. And sometimes people hear 50-50 and they think, oh, now we have to divide every asset down the middle. Well, that's not true either. I mean, you're not going to take your house and run a chainsaw through the middle of it. They did that on War of the Roses with shoes, I think, but you're not going to do that with a house. You're going to figure out offsets, or you're going to sell the house and you're going to split proceeds. What do I mean by offsets? That means if somebody gets the house and there's $200,000 worth of equity in it, we're over here looking for $200,000 in another asset to try to offset those things so that both people end up with roughly the same amount of assets. All right, so let's talk a little bit about what I said about those types of property. Separate property. That's something you have before you get married or someone other than your spouse gave to you during marriage. Could either be by inheritance, could be by a gift, but not gifts from your spouse. Those are also assumed to be marital property. Marital property, basically anything that comes in between when you get married and when you get separated, except for those things I just said, separate gifts from other people or inheritance from other people just to one of you. And then divisible. Now, this is a confusing one. This came about in 1995 to try to deal with some technicalities in the law that I don't need to get into right now, but it's really the growth on an asset or the loss on an asset after the date of separation. So if your retirement account is doing what mine's doing, going up and down with the economy, the lawmakers decided that wasn't fair to freeze the value as of date of separation, that both spouses should share in the investment gains or the investment losses so that neither one in an offsetting situation was getting unfairly dinged with a loss or getting a windfall with a gain. That's why that's there. So property can have all three of these things, and that's what mixed property is. Easiest example for mixed property is to think about retirement. Maybe you got married after you already have retirement at your job, but you continue to put money in your retirement account, or your employer puts money in your retirement account for you. That is what we call mixed property. The part that you had before you got married is separate. The part that comes in during the marriage is marital. And a good lawyer is going to help you figure out what each one of those components grew to in the market over time. Your separate property wouldn't be fair if you just got $30,000 back. You should also get your investment experience on that. So ED is complicated, and it's something I highly encourage you not to go through alone because you can really overlook some things. There are a lot of words around there surrounding custody of children that frankly don't make a lot of sense in North Carolina, and you really need to ask someone what they mean when they use one of these words. For instance, we say things like a permanent custody order, but guess what? Nothing's ever permanent when it comes to custody. It's always subject to change, not just on a whim, but because there's been a substantial change of circumstance. A fancy lawyer phrase, right? What does that mean? Well, that means that something has happened that is positively or adversely affecting the child, that a change in the custody situation needs to happen. Could be something like a parent's moving away for a job. Could be something like, I hate to say this, but a parent's gotten really sick and we need to change the custody situation because that parent can't serve as a caretaker anymore. Those are things that aren't as pleasant as perhaps a child's gotten into a fabulous school, but because of that, somebody needs to move and the schedule that they had in place isn't going to work anymore. Those are some examples about things that could change. So permanent never means permanent, even though the court order says it. Okay, so what else about custody? Some phrases get thrown around like joint custody, sole custody, shared custody. And I don't even know what somebody means unless they tell me what they mean. When they say joint custody, are they meaning time? Are they meaning a true 50-50 division of time with the children? Or are they meaning joint decision making? So let's break it out a little bit differently than just those words. There's legal custody and there's physical custody. Legal custody is about who gets to make decisions. That can be decisions about school, religion, even alterations to body appearances like tattoos and haircuts and piercings. It can be decisions about economics. It can be a lot of decisions about the children. But the question is, who gets to make those? In a true joint legal custody situation, both parents have to consult together, and if they can't agree, well, that can be a problem because there's usually no tiebreaker in place. Occasionally, we might say a pediatrician can answer questions about healthcare. We might say a school counselor can answer questions about school. Other times, people might say, we'll go to mediation. Other times, people might say, we're going to have to go to court if we can't agree. Joint legal custody is usually what happens here in North Carolina, except in situations where the parents have shown they can't agree to much of anything, or one parent is just disinterested in making these decisions or never responds. In those cases, you might see what we call sole legal custody, which means one parent gets to make the decisions about these things. I've even seen situations where they've divided legal custody. One parent gets to make medical decisions, the other parent gets to make extracurricular decisions or school decisions. So really, you need to know exactly what someone means when they use these phrases. Going back to my example about joint custody maybe meaning 50-50 time. That is a misnomer in North Carolina too. It doesn't necessarily mean that. What joint custody truly means in North Carolina when we talk about physical custody is a shared parenting arrangement. But sharing doesn't have to be a 50-50 division. It could be week on, week off, which would be 50-50. It could be long weekends, every other one. It could be lots of different schedules. So you need to ask a lot of questions when somebody says, we're going to separate and I want joint custody of the kids. What does that mean to them? What does that mean to you? You may find out that you're not on the same page. We get a lot of questions about child support as well and what it covers and what it doesn't and how it's calculated. Let's talk about how it's calculated first. In most situations, we calculate child support in North Carolina based upon the child support guidelines. That is a worksheet, and it's based upon how many overnights the parents have with children, how much money the parents make, whether or not the parents have another child that they are supporting from another relationship, either before or after this child in question, what the daycare expenses are, what the health insurance costs are for just the children, and any extraordinary expenses, for lack of a better phrase. This could be things like tutoring. It's also been known to be extraordinary cost for transportation for the children, for visitation, and other things along those lines. That would be more in a situation where the children are having to get on a plane to visit the other parent, not going across the county, of course. Okay, so numbers go in a spreadsheet, spits out a number, and that's the presumed amount that someone should pay as child support. What does that cover? Well, that's everything that the parent gets from the other parent to pay the child's expenses. If you're paying, you don't get an accounting of where the money was spent. And if you're receiving it, you don't have to account for where you spent the money. But what you do need to do to serve your child is be sure you spend it on the things they need. Defraying the cost of your living, your utilities, clothes for them, snacks for them, food for them, the water, everything that involves your basic living expenses. And if you're receiving it, you're likely going to say it's never enough. And if you're paying it, you're probably going to say, this is more than I think it would cost. And I know I'm being a little presumptuous when I say that, but I'm just basing it upon what I've heard in 25 plus years of experience. And I think that's just the way it is. It's kind of like also when you receive income. It never feels like it's enough, and your employer sometimes thinks it's too much. It's just the way this works, and it's the way that we have a relationship with money in America. But it is what it is on the worksheet, and it's very hard to get someone to pay more or less than what the presumptive guideline amount is because it's so set in stone in North Carolina and has been for decades. We review these spreadsheets every 4 years, where the judges do anyway, and they make adjustments for cost of living. So as you can imagine, sometimes inflation well exceeds the adjustments the judges have made because inflation moves a lot faster than 4 years. So yes, we know sometimes it's not enough. Now on the flip side, there are situations where these guidelines won't apply. If you're a high income family, and our statutes define that as combined income from both of you of more than $40,000 a month, that's $480,000 a year, then these guidelines don't apply and you're what we call off the guidelines. We have to look at then your ability to pay, the other person's ability to pay, and what the children's actual needs are, balanced against the standard of living that you helped create for them when you were together. And if you weren't together, the standard of living that they had during your relationship. Okay, there are a few other situations these guidelines don't apply in either. And that's when income is so low that if you paid what the guidelines said you had to pay, you would be below the poverty level in America. Well, for North Carolina, I should say. And if that's the case, then there's a section of the guidelines that says this is all we can ask this person to pay because we cannot put somebody below the poverty guidelines to pay child support. That's the way the law is. I know that's unfortunate if you're the one receiving it because you know that you need more, but this is how our law works right now. And lastly, a few reasons to go off the guidelines could be because an assumption in the guideline isn't true. The guidelines assume that everyone has housing expenses. What if your housing is paid for by your company or the military, or you live at home with a parent and you don't contribute to housing? That would be an assumption that isn't true. Another assumption is that you have food expenses. What if you travel all the time and you get a per diem and you don't have actual food expenses? Those would be reasons that somebody would do what we want to call a deviation from the guidelines. And we'd treat it just like a high net worth case where we say, what are the actual needs of the children and who has the ability to pay what and what was the custom standard of living for the parties. Child support seems simple at first because you can go on the line and you can get these spreadsheets and you can enter your data and it will spit out a number for you. But if the inputs are wrong, the output is wrong. You should have a lawyer look at it for you. Now, a lot of states use the phrase spousal support to talk about support from one spouse to the other during separation and even after divorce. North Carolina, we have two different terms. One is called post-separation support and one is called alimony. So I'm going to distinguish the two of those. Really, just think of post-separation support as temporary alimony. It's meant to be more of a band-aid on a situation where maybe we don't exactly know all the facts yet. We don't know who's going to get which property that might produce income or might have debt with it and some other things, but we know that there needs to be some support flowing from one side of the equation to the other to make things more, as the law says, equitable, fair. Again, hard for me to use the word fair when it comes to divorce and separation because a lot of things don't seem fair, but that's the word the law uses. So post-separation support, how's it calculated? If I knew that, I would love to give you a formula and tell you, but really there's no hard science to it. In most all counties in North Carolina, you're going to fill out a financial affidavit and you're going to say, these are my expenses. And the other side's going to fill out a financial affidavit and say, these are my expenses. And on this affidavit, both of you are going to list your incomes, if any, from all sources. And then what does the judge do? Depends on your judge, depends on your county, maybe even depends on the day you're in front of them. A judge is going to look at everything and say, does this person have a need? Were they a dependent spouse during the marriage? Which basically means, did they rely upon income from the other person to meet the expenses of the household? And then they're going to look at the other side and say, is this person a supporting spouse? Were they the one who was bringing in more of the money to help support the family? And if so, that is step one, determining dependency and supporting. Step two is determining how much. Now, just because you were dependent and the other person was supporting, or vice versa, doesn't necessarily mean that spousal support is going to be paid. Why? Because there might not be enough money to go around after all the bills and the needs and the expenses are taken care of. Notice I said needs, not wants. After all the needs and expenses and the bills are taken care of. And that's practically just true. We know that two households don't live as cheaply as one. So a judge has to do some math and has to say, is there money left over after the supporting spouse meets the obligations that supporting spouse has, including child support, if any, mortgage payments, if they're the one keeping up the mortgage, car payments, because they have to have a vehicle to get to and from work. In most places in North Carolina, we are not heavily reliant on public transportation here. So is there enough money to go around? If there is, a judge can award post-separation support. How much? Depends upon what the judge thinks is fair and reasonable that day based upon the situation. Now, it's a little bit different than alimony, even though the math is the same. And I say it's a little bit different than alimony because in those situations, a judge is looking more at long term. How long should alimony be paid for? And there's no rocket science on that either. It really is a list in the statute of many, many factors that a judge can consider to determine whether or not alimony should be paid and for how long it should be paid. But here's one that is written in stone. If the supporting spouse committed adultery, he or she will pay alimony. Might only be $1, but he or she will pay alimony for however long the judge says. But if the dependent spouse committed adultery, he or she is entitled to $0. That's right, $0. You might have a need for $4,000 a month, and the other side might have the ability to pay it. But if they can prove that you had a physical adulterous relationship with someone, that's it. $0. No alimony. I want to distinguish that from post-separation support, though. Adultery is not a bar to post-separation support in North Carolina. So we've seen some cases where people have gotten a year's worth of support even though they had an affair. So yes, cheating does matter in one area in North Carolina, and this is it. It's in alimony land. The other thing you should know about alimony is that attorney's fees can be awarded too. How much? Again, completely in the judge's discretion based upon what they think is reasonable. So alimony is a complicated thing. It is not a simple mathematical equation, and you would be well advised to get an attorney who specializes in family law to help assist you navigate this so you can know what you could expect to receive or what you can anticipate paying. What does modifiability mean? If you have a court order for child support, for custody, for alimony, those are subject to modification. That's how North Carolina law is written. That's good, that's bad. Kind of depends upon which side of the fence you're on, I guess. For instance, if something was going horribly wrong in the other parent's life and you thought they were now a bad influence on your child, you'd want your permanent custody order to be modifiable. So North Carolina says it is. You have the right to go to court and you have the right to seek a modification to say, hey, this order is no longer best for my child. This person is doing drugs, this person has a gambling problem, they have unsavory people in their house, whatever's going on that's not for your child. You can go to court, you can present that evidence and seek a modification to your custody order. And I think this is a good thing because who wants something set in stone if it's not serving their child? Related to that, we have modifiability of child support. So child support, your order may say it's a permanent child support order, but if something changes, again, you'd want that flexibility and that freedom to be able to change it. And because our court says it should be a, quote, fair and reasonable order for child support that meets the needs of the children, as you can imagine, if those children's needs dramatically change, then that could be grounds to modify child support. For instance, and I wish this on no one, but if a child becomes sick and the insurance expenses are mounting or the deductible has to be met, there's something in there that just isn't working anymore the way that it used to work, that would be a potential ground to modify child support. On the flip side, something wonderful happens. Your child has made it on the Olympic team, but there's all kinds of more training involved and equipment and travel. That's something you could go to court and say, hey, my kid is now playing Olympic level soccer and I need help with these expenses because this is best for our child. That would be something you could ask the court to consider for a modification of child support. All right, and lastly, alimony. And this one can be a little controversial, but nonetheless, the way the law is written is that alimony is modifiable. Again, not just because somebody wants to pay less or not because somebody wants more, but because there has been a substantial change in a condition that makes it equitable, reasonable, fair, whatever you want to call it, to alter the alimony amount. Maybe someone got very sick and they're on disability now and they can't pay what they were supposed to pay. That would be a ground to modify alimony downward. Flip side, if that happened to the other spouse, the one who was receiving the alimony, that could be a ground to seek the court to order more alimony paid. I know that this one doesn't seem as fair because it seems like, well, this isn't related to children, Jenny. These are adults. They can figure things out. And when we understand the other ones because we want to take care of our kids, but adults shouldn't 5, 10, 15 years post-marriage, shouldn't they be able to figure this out and take care of themselves? Well, that may be your point of view, but North Carolina law's point of view is no. We want the alimony system to be, air quotes again, reasonable, equitable, and fair, and it wouldn't be fair for a situation that would have changed your life while you were married and you would have figured out how to solve it together, not to be a situation that alters the finances now, even post-divorce. Not everybody agrees with it. I'm not saying you have to, but that is the law. So modifiability, lots of quagmires there, lots of minefields, lots of pitfalls, some upside depending on which side of the equation you're on, but it's definitely something you want to talk to a lawyer about if you think your order needs to be modified. What is mediation in North Carolina? Basically, it's a private meeting where you have a mediator, which is a person that has been trained to help resolve disputes, go back and forth between two different rooms, or in this day and age, two different Zoom rooms, and help you and your spouse reach a resolution. But it's not the first place you start when you're thinking about getting separated. And a lot of people think it is, but I'm going to tell you why it's not. Because first of all, people have a misconception. They think a single mediator can represent both of them. And that's not true. A mediator represents no one. So a mediator can't represent either one of you. A mediator is just there to help the process and to help you come up with resolutions that you want to agree to. Lawyers can go to mediations with you, and we highly recommend that. And that's not just because we're lawyers. We highly recommend that because then you have someone there who can give you legal opinions and legal advice and tell you how things might go if you're not able to resolve things. But even more importantly than that, lawyers can draft the final settlement documents, the documents that resolve your situation so that you can walk out of mediation having everything done. A mediator, they can't do that for you. They can't do that because they can't draft the legal documents. That would constitute giving you legal advice, and you might be in an adverse situation with the other side, and the mediator can't give advice to two people who are on the opposite sides of the equation. They can't give legal advice, and they can't prepare the final legal binding documents. At best, if you go to a mediation without a lawyer, all you're going to walk away with a piece of paper is something that we agreed to in mediation, and now you've got to go somewhere else to make it enforceable, either in a court order or in a contract. So that's a big misconception, and I wanted to clear that one up. The other misconception about mediation is it's quick. Not necessarily true. It takes as long as it takes. Sometimes somebody processes faster than others. Sometimes someone's more prepared than the other. So it takes as long as it takes. Yes, it's a lot quicker than going to court any way you slice it, but it's not necessarily a 1-hour meeting and you're done. Rarely does that even happen. Rarely do you even get really started in the substance in the first hour. Another thing that's really important to know about mediation, in my opinion, and I've mediated for decades now, is that you need to be prepared. So thinking that you want to be separated and then saying, "Hi, I want to mediate," isn't your smart strategy. What's smart is figuring out, what can I afford? Can I keep this house? Can I refinance this house? Am I qualified to refinance the house? Who might we want to sell the house? What are my things worth? How much money do we owe? How much money do we spend? Those kinds of things need to be known. Otherwise, you're basically going into mediation blind and just saying, well, I'll agree to something, but who knows if it might work later. Not smart. So be smart about it. Get your documents together, get organized, and talk to a lawyer first before agreeing to go to mediation. How are mediation and arbitration different? Well, the biggest way they're different is that arbitration is basically like private court. You hire someone to be your arbitrator. They're a person that you may not know, you may not have ever heard of, but they're going to serve as your private judge. You're going to present evidence to them. You're going to talk to them. You're going to tell them things, show them things. And at the end of the day, the arbitrator is going to make a decision and say, this is how it is, just like in court. And when I say at the end of the day, I don't mean the literal day. It could be 30 days later or even more. Could be faster too, but usually within 30 days, because that's what North Carolina statutes say. So you toss it all up in front of an arbitrator, and the arbitrator says, this is who's getting that, this is who's getting this is what we're doing with the kids, here's how much money is owed, move on your merry way, here's your final document. There's very little grounds to challenge an arbitration. There are a few in our statutes, but very little grounds. Similar to court, because there are a few grounds to challenge a decision a judge makes on an appeal, but it may not be cost effective, it may not be what you want to do. So think of arbitration similar to court. You put forth testimony, you put forth documents and evidence, and the arbitrator says, this is how it is. Compare that to mediation. Mediation is completely different. Rarely will you be in the same room with the opposing party. Usually the mediator will go back and forth between the rooms. It is a lot less formal of a process. There's no evidence. There's no testimony. Yes, there's talking, and you're going to explain your position, and you may need to show some documents to support your position, but it's not nearly as formal. It's not the stuff you see on TV. It's not dramatic, and it doesn't take, sometimes it doesn't take, I should say, the emotional bandwidth that arbitration does, where you're always wondering, what is this person thinking? This person's going to make a big decision. Did I say that right? Did I say that wrong? Mediation's a lot more flexible. The mediator there is not there to, quote, judge you and make decisions based upon what you say. The mediator there is there to help you craft potential outcomes that both sides might agree to. And at the end of the day, if you don't agree, okay, you walk out and you don't have an agreement. It's not the best resolution, but you still have options in front of you. At arbitration, you might not agree with what the arbitrator has said and done, but you have limited options about where to go next. In mediation, you can always try another mediation. You could try a settlement conference, or you could go to court, or guess what? Arbitration. So mediation, you have some control still over what happens, and nothing happens unless you agree to it. Arbitration, very similar to court. You put your best foot forward, and you hope the judge does something similar to what you want. Same thing in arbitration. You put your best foot forward, and you hope the arbitrator does something similar to what you want. Which process is right for you? That's something you should discuss with a lawyer. What do the initials DVPO stand for? Domestic Violence Protective Order. You'll hear people use both of those phrases, but you'll also hear restraining order, and sometimes you'll hear a civil restraining order, and sometimes you'll hear a civil domestic violence order. It's all the same thing. Basically what it is a court order that protects one person from future domestic violence. How does one get it? They go to court, they present evidence, roughly for 10 days or so, if they prevail, a temporary ex parte domestic violence order is in place. Ex parte, Latin phrase meaning one party, which means that the order was granted only hearing one side of the situation. You, if you're on the other side of it, have the opportunity to go to court and defend yourself and talk about what happened as well. And the judge, at the conclusion of both sides of the situation, will decide whether a domestic violence restraining order should be in place for a year or so. So, if you get served with one of these, meaning the sheriff comes and finds you, or you pick it up at the sheriff's office, please respond. Don't just let it go to the back burner. This is very important. There are severe consequences to having a DVPO entered against you. You could lose certain rights, certain privileges, including when and where you can see and talk to your children. You lose possession of weapons and the ability to buy another one. And that's a good thing, I think, if you have committed domestic violence. But if you haven't, that's something you don't want to just let pass by. So see a lawyer if you've been served with one of these, and be sure that you don't sleep on your rights. And if you've gone to court and you've obtained one of these, and you want protection of the law, be sure that you go to your court date and ask for it to be extended. Don't not go to court, no matter how afraid you are. You took the first step to get a DVPO. Take the next one and get one that will stay in place longer. Both sides of this are very complicated, but at the end of the day, the judge wants to try to curtail domestic violence, and they're going to enter an order that they think will do that. You need representation no matter which side you're on to help you get the order that you want and you deserve. Now, we all know what a referee is in sports. They're usually the ones in the black and white stripes. They have yellow cards in their back pockets, maybe yellow flags. They have whistles. They're teeing up coaches. They do all those kinds of things. That is not what a referee is in divorce world. Predominantly, referees in divorce world deal with personal property disputes. Why? Because our court system doesn't want to deal with your pots and your pans and your TV, and it bogs down the system dealing with personal property. Judges would much rather be entering orders that help children be taken care of, or help spouses get back on good, solid economic footing, or even dividing up money, than they would to deal with your stuff. So, sometimes judges and sometimes people in mediation will agree to a referee. Judges will appoint a referee, parties can agree to a referee. Either way, I'm not showing up in black and white stripes. What that means is you go and you meet with a referee, maybe on site, maybe in their office, maybe by Zoom, and they listen to your personal property and they make a recommendation about who should get what, how much what is worth, whether it was marital, whether it was separate, etc. It's not binding though. It still has to go to the court and be approved because the court has said, I want this person to help me out by doing this part of the case, but I, judge, still have to approve it. And that's the only way a referee is legal. You can't have a referee just say, here's my binding decision, go follow it. That's not how the law works. But that's how a lot of people think it does. So be clear if somebody's mentioning to you, we'll just go see a referee about our personal property. Is that really what they mean? Or do they want to go to a binding arbitration where whatever that person says is how it is, and you don't have to go back to court again? Seems like to me it's an unnecessary process to go back to court again. Just go to arbitration and get it done. Injunctions and restraining orders are powerful tools that the court has at the disposal to either stop someone from doing something or compelling someone to do something. So when are they applicable in North Carolina? Well, we commonly see them in really two areas. One is custody. Maybe somebody's trying to move out of state without having yet entered a custody order, and they're trying to get away from here so that North Carolina doesn't deal with the custody situation. It's possible to get an injunction and a restraining order entered to stop them from moving, or at least stop the children from relocating outside the state until the court can hear the case. What is a restraining order? A temporary one is an order the court enters for maybe 10 days or so based upon one side's evidence, one side's words, one side's testimony, or maybe just one side's motion, and says, you know, if everything in here is true, then I think that there would be some irreparable harm in this case, harm that can't be remedied after the fact. So I'm going to put this injunction in place so that that doesn't happen. And then you come back in 10 days' time, or thereabouts, sometimes more, sometimes less, depending on the court schedule, but you'll hear a lot about a 10-day return, so that's why I'm saying 10 days. And the judge will hear both sides of the story and decide whether or not the judge should enter an injunction, which is more of a permanent thing that says, until further order of the court, I am stopping this action from happening. Or, in a positive world, I am making it mandatory that this action happen. That's a positive injunction. So another situation where it could happen is, I've had some medical issues before where the parents haven't been on the same side and they've had joint legal custody of the children, which means that they have to reach a joint decision. Well, one parent was being very clear that they didn't care what the other parent said. They were going to go down this course of medical treatment that would have had some harm done potentially that could not have been reversed. And so we filed for injunctive relief and a temporary restraining order saying, until we can get in the court, judge, and you can hear both sides of how the parents feel on this issue, please don't let this happen. That's one situation. Another situation where injunctions and temporary restraining orders can come into play are in money cases. In situations where somebody may be in fear that the assets are going to be liquidated. Maybe somebody's threatened to cash in their retirement. Maybe they've already taken more than their fair share from the bank account, and we don't want them to take any more. Maybe, on the positive side, You can get an injunction that says this person needs to cooperate with selling the house because failure to do so is going to cause them to be sued on the contract that they already signed to sell the house to these nice people down the street. And now this person wants to be a stubborn you-know-what and not sign it just out of spite. A judge can force someone via an injunction to go along with the sale. So think of this as a tool that the judge has in their toolbox to help when somebody's doing something you want to stop, or when somebody's not doing something they're supposed to do under an order or an agreement and you want them to get it done. Very, very, very complicated area of the law because it's all in how you say the things you say that first time you apply to court to get the court to help you. It's going to be an area where you're probably going to want a lawyer who's had experience with this stuff to help you instead of going on your own. To get divorced in North Carolina, someone has to be the first one to file. What do they file? It's called a summons and a complaint. The summons is a piece of paper on the front that says, in not so nice words, "Hi, you've been sued and you have 30 days to respond to this lawsuit or else the court might take action." The complaint is the document behind it that says things like, "I'm a citizen and resident of North Carolina and my spouse is a citizen and resident of blah, blah, blah. And I want to be divorced because I've been separated for more than a year and a day. And we have not resumed the marital relationship." That's what it is. If you don't have any objections to anything in there and it's all true, you don't have to respond. You might want to because it could speed up the process, but you don't have to. So what's important if you get a summons and complaint? Well, what if there's something in there you don't agree with? Maybe they're asking for alimony and you say, they're not entitled to alimony, they had an affair. Or, I don't have enough money to pay alimony. Those are the kinds of things you definitely need to respond to, because if you don't, a court could say you admitted it because you didn't respond in that 30-day window. So that's a big deal. Get a summons and complaint, whether that's from the sheriff, from the post office, from UPS, FedEx, whoever. Better call a lawyer and see if you need to do something to preserve your rights. And that's not just if it's for divorce. You could get a complaint for anything. It could be child support, it could be custody, it could be equitable distribution, it could be alimony. In fact, it even could be a complaint saying that somebody wants your dog. You need to respond. Have you ever heard somebody say, "I'm going to sue them for contempt"? Well, what they actually mean is not that they have a bad constitution or they're angry or grumpy or they're acting contemptuous. What they mean is somebody isn't doing what the court order says, and the court could hold that person in contempt. Why we use that word, I don't really know. But what it means is the court is going to decide whether, one, they want to make the person comply in the future, which is what we call civil contempt, or they want to punish them. They want to punish them for not doing what the court order said, and that's criminal contempt. Either one isn't great because it means you're disobeying the court order and now the judge is going to take some action against you in the future. Might even mean that you have to pay the other side's attorney's fees. So that's what it means to be held in contempt. It means the court has determined you're not following their order and you should have consequences. You may have heard someone say they have a consent order. What does that mean? Well, what that means is they were able to resolve their differences in the lawsuit without having to appear in front of the judge, say things, offer up documents, give testimony, and have the judge say, this is how things are going to be. It means they worked things out. But because there was a lawsuit, they still needed the judge's signature on it. Or maybe they just wanted to have a consent order because they wanted it to be enforceable by court in contempt hearings so that somebody could be punished if they didn't follow what was agreed to. Either way, whatever their reason, that's what it means. It just means it's an order of the court, but there wasn't a hearing, there wasn't a trial. The people agreed and they signed it and the judge signed it too. Have you ever been watching a movie and saw a guy in a trench coat hop out of the bushes with a piece of paper and say, "You've been served"? If so, that's service of process. But what does that really mean? Generally, it means a complaint and a summons have been served on you. And what are those? One, the complaint is the piece of paper or multiple pages of paper that says somebody's suing you and this is what they want. And the summons is a piece of paper that goes on the front that says you have 30 days to respond. So service of process is nothing more than the court's way of knowing that you have the paperwork and that you've had notice that you're being sued and that you have an opportunity to respond so that your constitutional rights are met. Notice and opportunity to be heard, as you may have heard before. So don't make it more complicated than it is. That's what it means. But what you do need to do is take steps. You need to respond because there are things that you need to do in a certain time frame to protect your rights when you've been served with a lawsuit. If you've heard, I'm going to file a motion against you, what does that mean? Well, depends on what kind of motion it is. So first of all, what does motion mean in the legal context? Well, it just means document that someone files with the court seeking the court to do something. So it could be a motion for contempt, which is if somebody's not following a court order and they want them to be held accountable. It could be a motion to compel, which is nothing more than, hey, they're supposed to produce all these documents. They were required to produce these documents and they didn't. So judge, hold them accountable. It could be a motion to modify something like child support or custody or alimony because the situation has changed and somebody wants the alimony or the custody order to change. It could be a motion for injunctive relief. Maybe somebody's getting ready to deplete the assets or go out of the country with a child and you want to stop them. There's all kinds of motions that can be filed in North Carolina. This is just a handful of them. But really what you need to know is somebody is seeking the court to help them with something and it might be something you don't want. So if you get served with a motion, you definitely need to call a lawyer. A subpoena is nothing more than a document that compels you either to come to court or a deposition and to testify, or in lieu of that, instead of that, to produce documents. But it can be very daunting to get one because usually it's a short turnaround time. It says you got to give us all these documents in 10 days. The good news is on the back of a subpoena, there's a list of things that you can object to. But you have to object, and there's particular time frames for you to object within if you plan on not fully responding to a subpoena. You can't just ignore it. It's the same as a court order. A judge can go get you picked up and brought into court if you don't comply with a subpoena. So don't ignore it if you get one, but call a lawyer if you need help with it. What is discovery in North Carolina? That is one word that we use to encompass lots of things. It could be what I'm going to use some more legal words on now. A deposition, request to produce, request for admission, or interrogatories. And sometimes people would even say subpoenas fall under the definition of discovery. But let me break all those down for you. First of all, a deposition. That is basically out of court testimony that is sworn in front of someone who's recording it so that it can be used in court either for you or against you. So a lot of times, if you have a court case and you have some confusing issues or you have some topics that somebody wants to know something about, they want to take a deposition. And they want to do that so they can ask you questions, quote, on the record, and you are sworn to tell the truth, the whole truth, and nothing but the truth, so that they can have a preview of what the testimony is going to be like in court, so that they can honestly respond to what this testimony is going to be, or counteract this testimony, or figure out how they're going to rebut or disprove your testimony. So that's a lot of reasons that people do depositions. And sometimes it really is just for what we call the discovery process, which is we need more information. You say that this asset has both marital property and separate property components, but we don't see that in the documents anywhere. Help us understand. Tell us why. That is something you could do for a deposition. Now, I said that discovery also included requests for production of documents, and that's exactly what it sounds like. It's a list that you get that says produce this, produce that, produce this, produce that. And unless you object, you're supposed to produce these things. If you don't, you could be finding yourself at the end of a motion to compel where you're standing in front of the judge telling them why you didn't produce these things, and the judge may say, tough luck, because you didn't object. So you need to have someone go through this and help you determine what you do and don't need to respond to and what you should object to. And the same is true for interrogatories. Those are just written questions. Sounds all fancy saying interrogatories, but it's just written questions. But again, there are some that could be called, what we lawyers say, a fishing expedition, They're just too open-ended. They're too broad. They're too crazy. They're unrelated to anything that's at stake in the lawsuit. So why should you answer them? But guess what? You can't just ignore them, because if you do, again, you might be hauled into court on a motion to compel. You need to object, and you need to object timely. So you need a lawyer to help you with that too. And the last one, request for admissions. Well, that is a list of statements. It says, admit that, blah, blah, blah. Admit that you live in North Carolina. Fine. Admit that you live in Wake County. Great. Admit that you live in Wake County with Susie Smith. No, I don't live with Susie Smith. If you don't answer requests for admissions, you are deemed to have admitted them. That's right. That means the court can assume that everything they said is true and use that against you in court. So ignoring requests for admissions is even worse, in my opinion, than ignoring any other discovery request. The last thing I tied in here just a little bit is subpoenas. Probably not going to happen for you because you're a party, but you might have a friend or a witness or a relative or someone else that has gotten a subpoena to come to court. You can't tell them to ignore it. You can't tell them not to respond to it. But what you can do is you can tell them, hey, maybe you should hire a lawyer to see if you need to comply with this or not, or if you need to file objections. So discovery, it's for you, but it also can be used against you. So be sure that you're working with a lawyer anytime discovery is in play in your lawsuit. If you're in Wake County, North Carolina, and you're in the middle of a lawsuit about the claims surrounding your divorce, like alimony or equitable distribution or child support or custody, you have seen a notice that says initial information required. We call those initial disclosures. Well, depending on what the claims are and depending upon the current version of the local rules is what you have to produce. But what you need to know is you may need help with this. You may need help gathering your documents. You might need help assembling your documents. And even though they claim they write these things in plain English, some of the rules are a little confusing, some even a little contradictory. You may need help navigating all that too. So you can have a lawyer and a paralegal help you with that. But what you can also do is you can make it simple on yourself by using a checklist and saying, did I gather the tax returns they asked for? Did I gather the deeds they asked for? Did I do all the things they asked for? Did I fill out the financial affidavit if that was required? I just didn't put to be determined, to be determined, to be determined. The point of these is to help you avoid discovery. And if you don't know what discovery is, watch my video on that. Discovery is expensive and time-consuming and sometimes can be overkill. Most family cases, you'll get all the documents you need in these initial disclosures, provided that you do them. If you don't do them, you could be forced to have to pay the other side's attorney's fees and be compelled to produce documents on very short notice. So watch the time standards on the initial disclosures and comply with the list of things that are requested. Even if you don't have everything, it's better to say, I don't have those credit card statements right now, but I've written to my credit card company for them, than it is just to ignore it. Get a lawyer to help you with this so you don't find yourself in a bind or prohibited from putting on evidence later. What are initial disclosures? Well, I'm only going to address what they are in Wake County, North Carolina, because frankly, they vary from county to county depending on if they have family court rules or not, and then what their rules say. So in Wake County, if you have claims for child support, or you have claims for spousal support, or claims for alimony, or claims for ED, you're going to be required in a lawsuit to produce certain documents and certain affidavits, and those are part of initial disclosures. If you have money claims, meaning support claims, then you will likely be required to complete a financial affidavit, unless there's no spousal support and it's strictly a guideline child support case. Otherwise, you're going to be required to complete a financial affidavit. And that's nothing more than listing your income from all sources, as well as where you spend your money in certain categories. And you can always add categories if you spend money in places that you find isn't on the affidavit. Be really careful with this affidavit though, because this is what can be used by a court to determine how much support you should pay or how much support you should receive. Now, if you are in a situation where there's an equitable distribution claim or a property division claim or an ED claim, whatever you want to call it, then you're going to be required to fill out what we call an EDIA. That stands for Equitable Distribution Inventory Affidavit. This document is much more complicated. You have to list every asset, marital or separate. Say whose name it's in. Say what you think it's worth. Say what you think should happen to it. List anything you want people to know about the property, contentions you have, like, hey, this property might be in our joint names, but I put $30,000 down into it. That has to go on the Equitable Distribution Inventory Affidavit. There's a list at the back for things that you might assert that mean for a 50-50 distribution not to be fair, that you should get something more than 50-50. Those factors are at the back. The judges are looking at these affidavits when you're in court to determine whether or not they think you should do something other than 50-50. So what you put on these affidavits, which are sworn and signed under a notary oath, that you have completed this to the best of your ability and everything you say is true to the best of your knowledge, and if you don't know 100% for sure, that you believe it to be true. These can be used without testimony. So it's very important about what you put on here. And the documents that support these two affidavits are part of initial disclosures as well. So things like deeds and mortgage notes and your pay stubs and your tax returns and how much money you spend at daycare and how much money you spend on health insurance, how much money you spend on your life insurance, how much your housing expense is, and all of those things are all part of initial disclosures. It's really important that you produce what you're supposed to produce, because if you don't, someone can file a motion to compel against you. And what can happen there is you could be ordered to pay attorney's fees, and you could be ordered to gather all these documents in a shorter period of time, because sometimes support hearings come up quick, and these documents are needed for support hearings. What else could happen? You could be sanctioned, which is one of those lawyer rules that say forbidden. You could be forbidden from putting on evidence that supports your very claims if you don't produce it as part of your initial disclosures. So it's very important that you comply with the time frames. In our case, Wake County's local rules, but if you're listening to this from another county, your county's rules, not only the time frames, but also the list of documents. If there's something you don't have, simply because you don't keep those records, but it does exist, it's better to say, I am requesting these records from American Express or from my mortgage company or from whoever, than to just ignore the question. You need to let people know that you're getting the documents together and then produce them when you get them, instead of just ignoring the request. So that's my tip on how to keep yourself out of a sling in court and be able to put forth your best case. And if you have objections to any of these documents, maybe somebody owns an account with you and you don't want to disclose their confidential information, you better talk to your lawyer about that, because if they find that there's an account and you didn't disclose it, that's going to look bad, and then you have to explain it away after the fact. Take care of it on the front end and provide clarity to the other side. Now, you don't have to memorize all of this. Of course, you can refer back to the video whenever you want, but the important thing is that you know the terms, you're familiar with them, you know what questions to ask, you know how to protect your rights, and you know what you need to do. Schedule a free intake call with Triangle Smart Divorce today so we can help you set your smart strategy to addressing your situation.